Okay, so this next question comes from inside counsel who's frustrated and wondering why no one will fill out the invention disclosure form. So let me back up a little bit and say that most enterprises will have some sort of form to allow capture and tracking of an innovation that they might file a patent upon. So it's called an invention disclosure form. Typically, IDF is the acronym. So, what I found in many years of practice is the different firms I've worked at, they'll have, a, some templates or some forms that we'll hand out to clients. And these forms are very thorough. They have all the questions that you might need answered. And in fact, if you do fill out the form and you fill it out exhaustively, it will give your patent drafter a leg up, to draft the patent because it has all these key questions in there, different sections. The problem that I've had in my practice is nobody ever fills them out because nobody understands the form, unfortunately. So what I've done is I will meet with the innovators and we'll have a brainstorming session. I'll run a recorder and I will, in essence, fill out the form. The only luck I've had with getting the inventors to fill out the form were in two situations: companies that are very well organized and have a long history of IP and maybe some training around how to fill out the form, and you might get 50% of it filled out. The angle I've taken is to have as short a form as possible and as simple as possible. You need some sort of tracking number, probably an internal system or just make one up. You need to have a title. You need to know who the inventors are, or the potential inventors are, and their contact information. You need some sort of summary of the problem being solved and what sort of technology is used to go about solving it. And then there's a lot of questions beyond that that people will add in. One that I like is, what's the value? And you can get into really complex scoring of how good an innovation is. And I think of kind of two things primarily when I think of value: is how close is it to being in a product? Maybe it already is, or maybe it never will be. That's a really important factor. And then the relative value to the enterprise and the strategic vision. So I found at most those two dimensions are helpful. I've seen people try and use 13 different dimensions on scoring ideas. And then a thing that I get asked all the time is it patentable, right? Which is a really hard question to answer. Sometimes you'll do a patentability search that will get you closer to an answer. But typically, most patents issue 75% of all patents that are filed issue. So the answer is probably yes, if it's the sort of thing that you can patent. And, I have a good feel for what is easy to get through the patent office and what is difficult, because there are certain technologies that are really difficult to get through the patent office, such as GUIs, any sort of business method, anything around ed tech, software ed tech, AI algorithms, in the abstract. There's some more on the life sciences side that are really difficult to get through. So your patent attorney should be able to kind of guide you in that regard and have a good sense of what's going to get through and what's not going to get through. And one of my clients just told me my statistics had gone up. I had a 92% allowance rate. Now, if you try hard and long enough, you can get anything allowed. So I'm not sure that that's really elucidating, but But at any rate, most good counsel can get you a patent on a product you want protected. Maybe a very narrow patent with a very long claim, but nonetheless, you can generally get protection if it's the sort of thing that can be patented, except for a few exceptions in technological areas where patents are very difficult to get. So that's kind of what I think of in the form. You might ask, what's the deadline? And there can be legally driven deadlines, bar dates, and there can be some sort of event that's driving it. You have a product release or going to a trade show or some other motivation. And often, your inventors are not going to understand the legal issues when you ask them those questions. So it's hard to get a definitive answer there. And then there's probably, I've seen forms that have 60 questions on them. And I would be surprised if more than 6 ever get completed. And you just really intimidate the people participating in the patent program when you have a complex form. So my personal approach is have the simplest form possible, get on the phone and try and get some more detail on the idea, maybe run a recorder so that you can get all the information that your patent drafter will need to put together that draft. So at any rate, I hope that answers the question. I think there was some frustration. Nobody fills out these forms. When I wake up in the middle of the night, I'm in the middle of a dream as a patent attorney, I dream that everybody will fill out these complex forms because my life would be a little bit easier. But as it turns out, no one does, and it just intimidates people to try. So at any rate, if you got something out of this video, please give it a thumbs up. Don't forget to subscribe and leave your questions in the comments below. Thanks.